Well, let's see. Supreme Court. All right, now we're live.
Good morning. It looks like meeting is now streaming, according to what I see.
It is streaming, yeah. So basically, the equivalent of is it plugged in?
Right.
Yeah. I missed the on button this morning. It's going to be
well,
one of
have
those.
more coffee, Mike.
Yeah, one of those days, I think. I also failed the Wordle this morning.
Oh no.
Yeah.
I've debated doing Wordle. I feel it will become a time suck for me, so I've resisted it so far. But
Takes just a few minutes, but it is.
yeah. Oh well, I'd find a way to make it take longer. I'd go randomly looking up the word and reading definitions and
Yeah, the only other time I didn't get it was a word I didn't know. I don't remember what something that it was like I thought the word was paper and it was something else. But it was a word I was not even familiar with.
What was it today? Something you feel you would have gotten?
Yes. I usually do this on the bus on the way in. So
Yeah.
it was spoiler alert. It was dandy this morning.
Oh, very nice. That's a great Friday morning word.
Yeah, it was a good one. Yeah. And 2 D's, and I guessed Sandy.
Oh,
Or
yeah.
what did I guess?
It could be anything. Sandy, handy, candy.
Yeah.
Right?
Yeah.
If you
Yeah.
don't
No,
have that
yeah. You know what? It was
initially.
candy
Yeah.
that I did as my last guess. And I'm like, oh, there it is. Nope.
Nope.
Missed.
Yeah. Those might be harder where there are so many options.
Yeah.
And double letters. Yeah.
The double letters are I didn't know that was a thing you could do at first. But
Right. I mean, on Wheel of Fortune, if you guess a letter,
you
if
get
it
them
appears
all,
more
right?
than once, yeah, they all show up.
All right. get going here in just a minute. Did you get a demo last week on what was your
On precision, I
week?
did
Crazy.
get a demo. I thought it looked pretty good. I wanted a trial password to try some things out myself, because I know they only show canned examples, of course, that really work. But I'm apparently not eligible for a trial password yet. I forget this always happens. The vendors, well, especially, I think this especially happens with Westlaw, because they were early on in having these patron access terminals that libraries could have. So they announce everything, but it's never ready for the patron access terminals until after everyone else gets on board. So they make sure it works for law firms and make sure it works for academic institutions. Then they try to figure out how to make it available to public libraries. Not sure exactly why that is. Yeah.
That doesn't make any sense to me whatsoever. I mean, the patron access is a super valuable service, and I am certain, as we've discussed before, that Thompson is not interested in offending the law librarians. But I also don't have access to a trial account. That's not available to me either. And I don't know how they frame it for solos, but Right. No, for us, they're like, well, it's not available for you to buy yet. So let's talk about something else you might want. I'm like, I suppose.
I don't want to talk about anything else right now. So we'll see. I did see law librarians have a couple of different national ways to communicate. One is through the association, and one is through this listserv that was set up out of UC Davis back in the 1990s. Law
really?
Still exists. It's mostly just a big interlibrary loan deal. People just say, hey, I need this article. Can anyone, look at this book and tell me the publication date? But every once in a while, there's something more substantive. And someone was saying, hey, what other firms have signed up for Precision? And she'd heard back. I don't think this person said how many people she'd heard back from, but she said, well, from everyone I've heard from, only one firm has moved to Precision. And a lot of firms are upset because they just decided to move to Edge. Law firms are notoriously conservative.
Yeah.
And so they're just like moving to Edge, and now Precision comes. So
that's a tough thing for Thompson, I'm sure.
Oh, yeah.
I also had a demo last week, and I loved, I liked it quite a bit, and I will probably upgrade. It's definitely one of those things though, where it's like, it's, I don't know if I'm getting enough additional substantive content that I care to pay for features, which should be part of the program anyway.
Yeah.
So it's
well, and I think we mentioned this last time. A couple of those features look super helpful for people in practice, but don't apply to a public access terminal. So you can't name a folder and store your research. You can't highlight things. All of those kind of added document management pieces don't really matter to us. We want to know about them so we can tell people they exist if they're thinking about signing up for Westlaw, but we don't use them. So all of that is super interesting, but doesn't help our patrons.
Doesn't necessarily. Yeah, I asked for a closer look of the visual research history. Map that they have, and that actually is the first I heard that. I'm like, well, who's going to use that? What's that for? I don't get it. But if you've ever scrolled through your research history, I'm like, what was I looking at? What was the, and
why
you can annotate it. We talked about that last time, but it is a good look at your research trail. And it is a quick way to identify where you've been and with your research. And I found it, those little things in the split screen with where you can edit you can start on your document within the same screen. Super practical things.
And
these are like
outlines,
feature enhancements that you just want from a premium service. And I'm not sure, extra $100 a month on my account is what so, but I mean, it does they are nice features. So
also the enhanced like results, search results, they looked really slick, but that's only available in certain topic areas, right?
Yeah, precision generally is only available in all of those specific practice, and they are rolling them out pretty quickly.
Oh, okay. Yeah. Because I was thinking if it's only a few practice areas, because again, as a library, we don't specialize in a practice area.
Yeah. Yeah.
So we only
I
want
don't.
something that sort of covers the waterfront. Same with
Yeah.
you. Yeah.
Yeah. I mean, I could be anywhere at any time. And so that was the other thing I had to pause. Though, if you are in one of those practice areas, it's like a ALR.
Hot dog. Yeah.
If you find the ALR that's on point, it's like, wow, that just made my life a ton easier. Right.
Yeah,
But
exactly.
they are rolling out a bunch of new practice areas but yeah, that was also a trigger there. It's like, just when it's a cost concern.
Right. Exactly.
All right. Well, we are 5 after that's our latest on precision. I'll be eager to play around with it a little bit more. Let's jump in today's most interesting legal research questions. I'm Mike. I'm a researcher at Gray Paper Legal.
And I'm Karen, director of the Hennepin County Law Library.
Hey, Karen. This week we had to address the Supreme Court issues. It's the first week of the term. Started on Monday with oral arguments, and I honestly was not super excited about taking this topic because some of the, most of the resources are super easy to find. I wasn't, but I did come up with 3 challenges and discussions with you and my colleagues for some more challenging research stuff. But let me start with you. Is there anything that you were thinking about in the first week of the term?
Well, here I play the role of the old person in our conversations, and I just think about how much easier it is to access what's going on with the Supreme Court. I mean, even non-attorneys know about SCOTUS blog. For years that was the researcher's big secret. Like, we know how to find things. We can figure this out. We'll go on SCOTUS blog. Well, now it's so mainstream. And it used to be, somewhat challenging to find things like transcripts or even calendars. I had a request last week or a couple of weeks ago in the law library for a citation to U.S. Law Week. And this younger law librarian was like, I don't know what that is. And I remember that was a B&A publication. It used to come out in print every week. And the lawyers circled like vultures to get their hands on it because it had the docketing information for the Supreme Court before the internet. You waited for U.S. Law Week to come out. So your topic made me think about how much easier it is to access information, but there's always the concurrent problem with that. And that's that there's so much information out there. How do you dig through and get to good stuff without losing your mind? And that's where you come in, Mike.
Yeah, that's right. Well, I think, SCOTUS blog, and that's what I say. Now there is a ton of information. I think, it's a highly politicized environment we're in right now. And as soon as there is a decision, it's everywhere. Oral arguments are easy to find. It's in the news. It's just, I think when I was at Thompson, they used to tell us that a Supreme Court case would be on Westlaw within 4 minutes, right after it's, wouldn't have all of the editorial enhancements, but and so it was, so I'm thinking, well, what exactly are we looking for? But there were three items that I came up with that we chatted about earlier in the week. One was one of the most interesting things was with the voting rights case, and then all the news articles talking about John Roberts having written these memorandum while he was at the Department of Justice, and I found those cited everywhere. I found them very difficult to find. Once I've figured it out, I'm like, oh, of course, I should have done that first. But it took me a lot. I did a lot of just Googling, Westlawing, a lot of just jumping around, and finally found in a PDF a citation to the National Archives, which maybe you are probably better positioned, and we should do a whole nother session, maybe a full CLE on searching government information.
Right. There's a ton of it, but the searching in it is not easy.
It is not easy. And here's the search box, right? There's not even an advanced link here. And so I did a lot of maddening searches here, not quite sure how it was operating, and I could not find it. And then I'm like, well, wait a minute. Why don't I use the Google search that I always use to find material on government websites that I found difficult to use? So this is the hot tip. Maybe I did cite arc. This is a Google search using some conventional Boolean, and cite archives.gov. That allows me to search that website in particular, and then I can just add in some Boolean operators like and then I can type in my additional search terms. So I did John Roberts, and the Voting Rights Act. And you see I get 49 results. I don't get 2 million results in 0.3 seconds. I get just 49. And this is the item right here at the top that I saw in the citation. I recognize the URL in the citation. And there it is. This is the memorandum that folks are talking about. It took me a long time to get there, I'm embarrassed to say. But after kind of messing around with the website, I finally was able to find it. It also seems to be good stuff like I think at GovInfo, also very difficult. This one does have an advanced search, but you have to know a little something about something, and this is why I think a good CLE on who's the superintendent of documents.
Yeah.
What's a SUDA class number? That'd be we should cover that. So I messed around in here quite a bit. Also didn't find it. There's another the hearings, the transcripts from the hearings are all in here as well, which are, so if you wanted to do again another site, GovInfo. This is a random thought on the segregation cases is Rehnquist. So Roberts clerked for Rehnquist, and that was this document. Rehnquist apparently wrote a random memo on why he thought Plessy versus Ferguson was rightly decided.
Yeah, wild.
Crazy. And I found that on govinfo.com. That search gave me just 2 results. Way down here, this is the in fact titled that, and then the actual memo is way down here somewhere.
And the reason you have so many hits there is it looked like when I was kind of redoing your search, Mike, like that did come up in Rehnquist's hearings upon being nominated for the Supreme Court. And so in all those transcripts, each senator who got up and said, oh, and another thing, because that's what they do over and over again.
Yeah.
So you get all those hits. But Mike, I think that's a good research point for everyone to think about. It's natural to think that once you find the place where you want to search, that their internal search engine should be the best way to get at the material. But I think we have to concede that Google's search engine is just incredibly sophisticated and has been. It has been for a long time. I remember probably 15 years ago trying to find documents on our own Minnesota court's webpage. And after a while, I thought, I'm not wasting my time on this page anymore. I'm going to go to Google the form name, add the word Minnesota, and invariably it would just pop right up and I could link into it. And I would even try to backtrack once I knew it was on the court website, try to back out and figure out how I could find it. I still couldn't do it sometimes. Now, I will say the court website in Minnesota has improved. quite a bit over the years. It's been built out more and the searching is better, but there are still times when I throw up my hands and I give Google a try. So I'm not trying to endorse a private company, but it works.
Well, they're big websites, right? I mean, most law firm websites are about me,
right,
my practice areas, my intake form,
exactly.
These government websites where there's serious stuff to uncover, those are big locations, and
Right.
who's going to build better search, Google or
Right.
the National Archives? I don't know. I mean, it seems like we could get good search from that, but the one thing I did notice is in running those searches that Boolean doesn't work strictly like Boolean. I call it Boolean, but I'm not actually 100% sure. I actually get more results by adding a term when it should limit, right? So if I do and term 1 and term 2, that should limit the number of results because it's requiring both, and that's not exactly what's happening.
Right.
A couple of my times I'm like, oh, well, that's interesting. I'm actually getting more results. I'm still getting good results, but
it's a little unclear what's going on. It must be adding synonyms or, looking at history and seeing people who search these two terms together are looking for this kind of thing. Yeah, who knows? But that's a great way. And the National Archives are sort of the government agency of the day these days.
Yeah.
You hear about them all the time. So
there's the final paragraph, signed WHR, where we found the memo, is that paragraph are saying it was rightly decided and should be reaffirmed. This last sentence here was what sort of got me excited about this query this week. For some reason, I'm like, I was poking fun at you for your incredible liberal media chops last week when you properly identified the term I bungled. As I bet you Karen has read Herbert Spencer. I was like, I don't recognize. Apparently this enactment of social statics is a reference to Holmes in the Lochner versus New York case.
Oh, okay.
I guess as I said, I was kind of hoping you knew a little something about it that I didn't, because I'm also likely to bungle this a little bit. But as I understand it, Herbert Spencer is sort of the father of social Darwinism.
It could be. You know what? I'm giving you nothing on this one. Yeah.
And this was a study done, by I'm forgetting the nationality, but they recommend the American Dilemma text as well, which is sort of more the liberal position. I mean, we talked about how recently it's been a politicized environment, but this is clearly evidence of, it's been a long history of partisan politics within the court. So I thought this is super interesting, and I thought, geez, I should, as a well-informed American, I should be maybe getting
go
up
back
to
and read
speed
those,
on
huh?
some of these references. Yeah. The other question I had this week was, I was wondering if anybody remembered this article from Thomson Reuters. This is a number of years ago now, but they found that the number of folks. This is a picture of all of the advocates that have argued before the Supreme Court, and it turns out there aren't that many of them, right? That the courts have sort of a regular go-to, and it's interesting, some of the statistics that are argued here, and we don't have time necessarily to get into all of that. This would be a great additional presentation if we ever did our own research on this as well, but noting that they are the elite of the elite. Far less than 1% of lawyers who filed appeals, and then the attorneys involved in 43% of the cases between 2004 and 2012. But just really 66 of the most successful lawyers, 51 worked for law firms that primarily represented corporate interests. And then this article has got sort of great visuals. There's Neil Kotchell. I'll get to see Neil at the Clio conference this week.
Oh, he'll be there. Yeah.
Clearly been to the Supreme Court a number of times, and then these great visuals. But all of this is to say that quick rambling is that this is the kind of research you can actually do with your Westlaw subscription, which I thought was kind of fun. If you do a search in the dockets, you can do a download to a CSV file and deliver basic information on the docket, which includes the names of the attorneys, the names of the case, the docket number. So some good information there. And this article in particular, this kind of research we can do specifically because it's easy enough to download a list of the names.
Sure.
You can see here I've been doing just a little bit of work on the data itself, because for folks who don't know, a CSV file is just stands for comma separated values. It's just an Excel file that has all the values separated by a comma. Unfortunately, the attorney names are all in one cell. But with a little bit of simple Excel functions, you can parse out those names and then get individual names. So I was just doing a little bit of work there. I'm in Google Sheets here, but then you can create a simple pivot table that'll give you a list in order of the attorneys who have been before the court most often. I thought that was kind of that was you can do some basic statistical research with a download from Westlaw using the docket search.
Boy, and it sounds like that article was about 10 years ago. Wouldn't it be interesting to see if that group of elite lawyers has become even more elite or if it's broadened at all? It'd be fun you can do that in all your spare time, Mike.
Yeah, I know. I wanted to do a little bit cleaner presentation of that. I thought it'd be fun to do. This is the search that I ran. If you do a docket, you're going to get kind of everything, including, minor issues. So this is one of the queries that I ran, and it gives me, not a ton of cases. After 2020 is just 41.
Sure.
If you download here.
And then one of your options.
List of items, CSV file, and make sure you grab all that are available and you can download.
And your drop down said CSV file because you'd done that most recently. The other drop downs are like
correct
PDF or whatever, text. Yeah.
That's exactly right. This is not my file. There it is. Bring it over just so folks can see it.
Yeah. Oh, yeah. Well, it shows up in pretty good shape to begin with,
It does.
Have something to tinker with. Yeah.
Yeah, that's why I wanted to show this rather than what I'd been messing around with. But you can do a little bit of work on this because these are separated by within the cell. They're delimited by a semicolon, so you can do a simple function to parse those out. Still have to get them aligned in a single column or do some other function to produce the pivot table. But all the data is there, so it's kind of fun to examine who did maybe replicate that research for more recent.
Yeah. Huh. Well, I learned something. Never.
Oh, did you?
Because usually with research, we're not, we're handing results over to patrons, and practitioners aren't as often wondering these more theoretical questions. So,
yeah, for sure.
So that's cool to know, though. Let's write an article or something.
I know. And I think it is sometimes more fun to move away from, think about some of those statistical, what else you can do with data. The information that we have available to us now is not just substantive legal documents.
Right. That's right. And to that, really, practitioners are interested in data. maybe not in this particular way, but maybe, if you have a great case you think should go to the Supreme Court, you want to know who's arguing those cases and who's succeeding and so forth.
If you're doing a bit of competitive intelligence work as well, I think, that's the kind of thing you might want to know. Now, there are a lot of tools that already do that for you. Westlaw's got tools for that. There are other resources. So, produce, we used to call them go to lunch reports, or I think there are other, but if you're pitching to a client, being able to look at the docket information and parse that information out and find out, where your competitors might be, or your clients, of course, is
right.
The good one. Where are they litigating? Who have their other attorneys been? All that kind of information is really parsing data, rather than doing other kinds of traditional legal research. So.
Right. That's right. Yep.
Let's jump into the Supreme Court. The third one, this one we actually did together, Karen, this summer.
Yep.
When the Dobbs decision was leaked, one of the interesting things was that the dissenting justices had drafted the dissent collectively, or jointly, or I'm not sure what the appropriate term, but as a single entity. Typically, when there's a dissent, one justice authors it and it's joined by the others. And so I was wondering, how common is it to jointly draft a dissent in that manner? So that also took me a little while to come up with a good search for that. Let me see if I've got that in my recent history here. I don't have it here. Let's I think I've got a sheet I can grab from, though.
It was a great search, Mike. I was impressed when you came up with it.
You're going to be excited to see it here.
Oh boy, I mean, you don't see the syllabus used in all that many searches.
Here it is. Actually, in the first part, I didn't have syllabus in here, but I took a look. The DIS here is the dissent. So in Westlaw, the cases are broken down at the appellate level. They'll have a space just for the dissenting opinion. It's not the dissenting judge. It's not the authoring judge. It includes that information, but it's the entire dissenting opinion. And at the top, it'll say, so-and-so justice dissenting, joined by, or in concurrence with the other justices. So I, kind of knowing that, I put together a search in the dissenting field, and justice +3 of justice just means that I require that justice appears twice, so that we're getting that joint dissent. And then I wanted to make sure that it wasn't just joining in, so I eliminated that with the % sign. That's in Westlaw, the standard Boolean is but not. So this is also a great example of just why we still might want to use traditional Boolean.
Right. And one of the rare occasions where you want to use but not. That's always been a risky term for me, because you sometimes inadvertently eliminate something you do want. But that's great.
And so the first thing I learned after putting that query together was, well, there are 2,000. Does that mean that there's a lot of them? As it turns out, that's not necessarily the case. So you get a lot of these cert petitions which have been denied, but you've got a dissenting statement by two. So that's not hardly, there's some interesting stuff in here, to be sure. But it's not the same kind of grand statement as the justices collectively writing a statement together. And so in order to do that, I added the term syllabus just to make sure I had that summary from the court at the top of the case, and I was getting, the more meatier items. But
which I think is
more meaty. The third petitions are becoming more and more, interesting.
Yeah, right. But I think that's a clever way to think about using syllabus. You're not trying to search within the syllabus field. You just know that if a case received a full opinion, it will have a syllabus. And so that's how you get at the full opinion cases, not just the cert denieds. So
yeah,
that was clever.
Yeah, and we're using that as a key term, right? Which is often mocked again, among our AI colleagues.
Yeah.
But this does an effective job of narrowing it down. But as a research tool, it works pretty well. I still have 13 cases here. Most, all but two are irrelevant to our search, right? But I'm only down to 13 results, so it's a good. I think it's a good mechanism for narrowing our results. And if some of these are just really mishits. I mean, they're not what we were looking for. There was just the one case, other than ours. I think, what was it? The third, way down here. I think here it is. It's the ACA case. Interestingly, so it was,
of course, also recent. I mean, that's very interesting, isn't
yeah.
it? I think it does tell us something about the character of the court being different, because the two times it's happened have been quite recently, and this was searching right throughout all of Supreme Court cases.
It was, and that's a great point. I thought of that as well, but I'm not sure to what extent these documents are coded all the way back to the beginning.
I wonder that too. Like, did they receive the same sort of, like, is the structure the same back in 1820 as it is in the 20th or 21st century?
Well, yes, and I just didn't know if Westlaw had done the work of giving the dissent. Is there I could have tested this actually. I did not, but I could have done a search, before 1950 or something.
Sure.
Maybe there are no dissenting fields. They may have not gone all the way back in time and applied the same coding to the documents, which is something you just have to be aware of and careful of. But for our purposes, and it would be interesting to do that, to take a look back. But it was interesting for the current documents. It was just you did see Scalia, Kennedy, Thomas, and Alito join filing the case as one voice, the conservative justices on the Affordable
ACA
Care Act
case. Yeah, man. So interesting. So it does. I think for researchers like Mike and I, you hear these kind of bald statements made in the news, like, oh, unprecedented manner, the justices joined in a dissent, and then you always think, I wonder how they know that. Is that really the case? And so it's interesting to go back and do a little double check.
And some of it, I think, is we're talking about Westlaw Precision, and how that tool has got a taxonomy of facts now, which is pretty cool, because there are common facts that matter to specific practice areas, and they have their editorial team putting that together, and that's pretty cool. That does nothing to help us with the kind of facts that these commentators are talking about, and how they're bucking tradition, how it's no longer, and I don't have an answer how to do that kind of research on some of these matters, unless because a lot of it has to do with tone and some of the deference that's no longer shown to party or I should say state officials, or what does that even mean? I'm not even sure. So precision's not going to help us with that kind of thing. And to a certain extent, we have to rely on some kind of trusted intermediary, like the experts at, but those are, also quite a bit partisan, and it's hard for us to figure that kind of stuff out as a researcher, I think. I don't know. What do you think about that? For me, it's that's kind of frustrating.
Oh, it's super frustrating. And even just like basic case law research. I remember many years ago, famous law librarian Bob Baring used to say, don't rely on the head notes. Maybe that editor out at West was having a bad day. Or she hadn't had her coffee yet that morning. You just don't know what the case says without reading the case. But of course, it's impractical. As humans, we can't read every case. So we do have to rely on an intermediary. And I think that's what the large premium vendors trade on, is their reputation in being reliable and reasonable in how they're characterizing cases. But yeah, I mean, that's always the question: is this really the thing I think it is when you're doing research?
Yeah, and when we're into the world of convention and political norms, I don't know. We don't, as I guess, as legal researchers, we don't have any set of tools quite often to rest on that kind of thing. That doesn't mean we're incapable of doing it. I mean, we could conduct any number of different kinds of surveys, but that we're now into, I don't even know what. I mean,
I don't know. Is that sociological? Yeah.
Yeah.
Political? Yeah.
Yeah. Or basic social science research, which
Right.
as attorneys, I barely competent to even use the terminology of quantitative and qualitative research methodologies and things like that. It's so I'm not sure what the appropriate steps or even what the useful exercises are. What do
Right.
people need to know at this point for some of those more political issues? So
yeah, for sure. Great way though to maximize the use of Westlaw to find out at least some information around these headlines that we're seeing.
Yeah, I mean, and we do have some tools. We're not totally hopeless.
Right. Yeah, between that and all that government information is rich in content. There's just so much of it. It's so difficult to find. It's been that way forever. In the old days, government depository libraries got all of these hearing information and transcripts in print, arranged by SUDOC number, as you mentioned.
Yeah.
And it was voluminous. And boy, those researchers who could work their way through that were really top notch, because that stuff is hard to find.
Yeah. We will definitely have to cover that in the next or in a next
in an upcoming.
Yeah. Government information is super interesting. And do you maintain those collections at the Hennepin County Law Library?
Hennepin County Law Library is not a depository. We get a few items from GPO and print still, statutes at large and CFR, things like that. But Minneapolis Central Library in Hennepin County is at least a partial depository, and the University of Minnesota is, I believe, a full depository. And of course, that's changed because now a lot of government agencies are issuing their publications online and they never are printed. So then trying to manage an archive of that is a whole new project.
And you wonder, I mean,
you wonder how much of that is lost.
Yeah,
for sure.
The other, and I'm not sure actually how it's currently being handled. The other Supreme Court issue on that point is link rot. I think Harvard did a study about the time this article came out here, finding I believe it was nearly 30% of, in the recent cases, 30% of the URLs referenced in Supreme Court decisions were rotted.
And how do you, what does that mean for researchers in the future?
Yeah. And there are tools now where, and I think you can, I think perma.cc, there are other tools that allow you to preserve those so that they're available for posterity's sake. Researchers. But it's
another interesting topic for sure.
All right, well, great. This is as more fun than I expected it to be.
Always interesting. Yep.
And I hope you have a great weekend. Have you got any plans for this weekend? I hope you're...
Well, I'm in Minnesota, so it's apple picking weekend this weekend.
Oh, very nice.
So just debating now between a cake or a pie when we get back from the orchard. So
very nice.
Those are the important things I'm thinking about. Or a crisp. I don't know. Crisp will be during the week. On the weekend, do something more elaborate. What are you up to this weekend, Mike?
I've got CleoCon, so the
Oh, right.
annual Clio conference is in Nashville this year, and so I'm going down there through Saturday through Wednesday. So that should be fun, I think. She said Neil Kochhouse is one of the keynotes, and but yeah, it's I've never been to Nashville actually, so it's gonna be 75 and sunny, so that'll be nice, I think.
I'll think about you if I get cold picking my apples. Maybe next Friday there'll be something that you discovered at CleoCon that we can talk about.
Yeah, you never know. I'll report on my visit with Neil.
Yes.
On the first name.
Oh yeah, you and Neil, old buddies.
Yeah.
Good.
Yeah. All right, Karen, you have a great week, and we'll see you next week.
Thanks. You too. Take care.